So first, I'm really honored to be here. That is the third year conference, and I'm participating in this conference for the third year. And every year, participants and their lectures, presentations are very great. I always leaving, as Lila said, with the new impressions, new knowledge, and also new colleagues. So I'm honored to be here and to speak, to address to you some selected issues, but I have huge problem because we are a group who work on the private rights, and many of stuff which I will have on the presentation is already told today or yesterday. So let me start. Okay. Perfect. As already many speakers before mentioned, we are celebrating this year 35 years of the Children's Rights Convention. That is also 65 years of Declaration and 100 years of the Geneva Declaration on the Children's Rights. So it's a great year for us lawyers who are dealing with the family law, especially with the children's rights questions. So United Nations Children's Rights Convention represents a catalog of protected children's rights due to their minor age and ability to understand their actions and their consequences. Children are a vulnerable group of population. They enjoy, therefore, special protection and care and have guaranteed special protection against economic, social, physical, mental, and other exploitations and abuse. But I call this so general protection. We have some children which need much more protection as, for example, their peers. We are coming from Europe. Children's rights here in Europe are protected much better as in other parts of the world. So, for example, there are children in war, not so far away from us. There are also street children that need also special protection. There are children from minority groups. We all have minority groups in our countries. We have also, because I stress, because in Slovenia, Roma population is not like a minority group treated, but they have the same rights. Then we have disabled children. Then we have indigenous, not in Slovenia, but they're in other countries. And we have all countries' children living in poverty. But if we combine these 2, 3, or even 4 circumstances, these special circumstances, the risk for children could be increasing. Could you imagine you have a girl, disabled child, born in minority group during the war to the unmarried mother? So it will be huge problems could arise from this such situation. Rights of the child in private law focus on ensuring children's welfare, protection, and autonomy within legal contexts such as family and civil law. These rights intersect with the family law, contracts, torts, property, inheritance law, social security law, and more about this intersection will you be able to read in my chapter of the book, and I will just give the presentation of selected issues. Yes, we already heard today many times that when the child is born, the child will get the legal capacity. That means that the child is bearer of rights and also obligations. But in Slovenian family law, I was very interested that none of the ex-Yugoslavian independent countries today have the definition of the child, because in Slovenia we also implemented the definition of the child in the new family code, which was adopted in 2017 and is applicable since April 2019. That means that the child is the definition is the same as in the convention. The child is a person under the age of 18. And under also the very important standpoint is that under Slovenian law, the definition of a child does not extend to the fetus. But, however, we have some open questions regarding this. Therefore, a child status is acquired at the birth and ends when the child turns 18 years. But the last week we have been here for another conference, we spoke about reproductive rights. So we found out that it's not even so anymore simple to speak about unborn child, because I mentioned also in my presentation there was a case, a recent case in the United States from 2022, when the court made the decision that frozen embryos which have been destroyed are treated as human. So they have been frozen, not even in the woman. So they have been also treated like a human. 18 years is thus accepted as the general legal limit separating minors from adulthood and children from adults. The onset of the adulthood is therefore tied to an objective chronological conditions. So that means that a person 17 years old, 364 days old is protected as the child. And tomorrow, that is not anymore the child, that is even adult person, which enjoys different protection. And of course, that is based on the presumption that child who will reach the age of 18 will be capable as the adult person. But if that not covers this situation, we know that we can go to the court and apply for the guardianship. But that is just based on the presumption. As already mentioned, at the 18, legal emancipation occurs according to the law itself. When I am speaking with my students, I'm always asking them the same question in the beginning, that not just students who are studying law, because I'm also teaching education law and also the nursing faculty. We know that are usually students about 20, 21 here, and asking, why have you been so happy to celebrate your 18th birthday? It is very interesting. They're from different faculties, and their answers are almost the same. On the first, what would you like to hear? That is, we can legally drink alcohol. The second one, we can drive a car. Third is, that was before, I will explain later, no, that is so sad, we will be criminally responsible. Okay, and the fourth one, no, we are free of our parents. So I say, so you are really happy about this, because we see parental responsibility will cease with 18 years. But that is for us parents much easier, because we don't have any obligations, except, of course, maintenance. In Slovenia is that bound if the child is studying, and just until 26 years. So in this case, adult children who are studying has the obligation to make their study progress properly. So as the parents, I am free, so I'm joking that we parents should have the celebration, not the children. Yes, it's true. You see it in the cake. Yes. Yes, I already mentioned before that in Slovenia the definition of the child does not relate to the unborn child, the fetus, but we have already, Timea mentioned before, so-called nasciturus fiction, which is in the case when the child is already conceived and the child will be born alive within 300 days after the deceased person passed away. That will be the status of the heir. I think that is in all state similar, but as already mentioned before, in this Alabama case, it was very interesting that also embryos has been defined as human. Testamentary capacity. No need for explain, we are all lawyers. But it is very interesting that in Slovenia, the children are treated as testamentary capable with the 15 years. So we can see that in Spain and in Austria it's 14 years. We heard today already that is in Serbia and also in Turkey with 16 years, and Italy and Portugal with 18. So I am asking, and to remember, in Scotland is testamentary capacity acquired with the 12 years. So I am asking you, are children in Scotland more capable of understanding what are they writing in the last will as the children or adult person with the 18 in the Portugal? Or are children in Serbia less capable as there in Slovenia, which is 1 year of difference? So you see that there are still many differences. And more, of course, more about age. As already mentioned, also today we have in Slovenia The child marriage is also possible, but it's not forced, at least not legally forced, because the court has to approve if child is enough physical and mental capable to understand the consequences, and so the court is protecting the child. But in some countries, they already abolished. The marriage is possible when the person is 18 years old. So should we make the same in Slovenia or in Croatia? I don't know, in other countries? That is not so simple to answer yes. Why? Because at least when the court will approve such a marriage, there will be a control. But on the other side, people can live together, especially by the Roma population in Slovenia, that problem. They're living with the young age together, and there's no control. So better to have control or to make the restriction with the 18s, and there will be still open questions. Also, with the new family code abolished the age limitation of 15 years for the acknowledgement of the paternity. That means that in concrete case, even 12 years old boy can give the acknowledgement if he would be seen as the capable. So it's theoretically possible. And then we have 15 years also in the family law that the child can conclude legal transactions, and if the child is employed, he can dispose with their salary. But we are all familiar with the problem of so-called kids influencers. We know that the children which are on the YouTube or other platforms, which are opening Kinder Sorpresa or some toys and very happy, and on the other side, parents are earning much more money for this presentation. There was this Chinese boy, I cannot remember the name, he earned in 1 year $26 million just from these such posts. And parents are saying that is not labor, the child is happy, she is very happy to make such presentation. But you have to know, if there is a clip for 2 minutes, there's much more work. That is maybe 1, 2, 3 days of filming such a kid. There's a scenario written, there's light should be a very good position. Children are tired. So what we see, this 2-minute clip, children are happy, but that is a lot of work. And we know that in some, for example, some countries, the children even do not go to the work, to the school, and there have been also cases because the parents forced, they have been starving the children, and parents have been accused by the court for the maltreatment of the children. So that is also not such an easy question. Then maybe 14 years, criminal liability and also tort liability. I mentioned before that when I ask my students, they're saying, oh, with 18 years, we are criminal liable. But that was maybe before last year. Then happened in Serbia, this tragic situation when a boy of 13 years killed peers in the school. And then our children also in Slovenia get aware, oh, I'm not liable with the 18, but with the 14 years. So on one side, that was good, because in schools, they're teaching about the children's rights, but they're teaching maybe in much more positive way, not critical approach. So children are not aware that are also tort liability and also criminal liability is gained with the 14 years. And then we have right to education also in Slovenia. The parents are obliged to enroll the child in the elementary school in the year when the child will reach the 6 years. And the primary school obligation is for 9 years, but that doesn't mean that the child will finish 9 years of education. It could happen that the child will go out of the school at the 7th grade because they have to repeat some classes. It could also happen. And also religious education of children, this act is saying that the child of the age of 15 can make own decision. But let's speak about, because in the last power presentation is regarding the Patients' Rights Act. Patients' Rights Act is saying that the child with the 15 years is able to give the consent for the medical treatment. That means that the child under the age of 15 is not capable. But in every single case, the doctor in Slovenia has to prove if the child older than 15 years is capable to understand, or even if the child younger than 15 years is capable to understand. That is especially in the case when young girls are going to go to the gynecologists for the contraception pills. So could happen also they're younger than 15 years. So the child can say no to medical treatment, but the child has no right to call the priest, because that is lex specialis, which is related to the fixed border of age limitation with the 15 years. Okay, I'm finished. That was already everything told yesterday, so no need. And that is also my colleague from Slovenia told about this today. Maybe just in one sentence to conclude this topic. We know that the children have right to be heard under the Article 12, and that is the court should make the possibility for children to express their opinion. And this expressed opinion is just one of the circumstances which the court should evaluate and follow the best interest. That means that not every expressed opinion, wish of the child will be made for best, will be in the best interest of the child. For example, just to last word, if the child of 14 years is saying in the worst case that he or she will want to live with the father because the father is more free, if the father do not make any time limitation with the using with the smartphones, the girl could be out on the weekend for free time, and the mother is more strict. 1 hour they have a smartphone, and you should be at 8 o'clock at home at the weekend. So the wish of the child is to live with the father, but I'm sure the court will evaluate this in the best interest of the child, because education is still very important to take care about the child. So that was very briefly, that is what I spoke about the autonomy, and okay, thank you.